From the offices of law firm of Sam Shihab and Associates in Columbus, Ohio. We're having this Monday 6 o'clock session today that we do every week at 6 o'clock to discuss immigration matters, employment immigration matters that are important to you and that we think is relevant, and answer your questions. Obviously absent today is my colleague Brian Burke and my partner. He is flying to Chicago right now to attend an adjustment interview tomorrow. However, so we can keep it interesting, because always to get Brian's input and opinion is important to our weekly presentation. We've recorded a little session yesterday on the weekend, and which we're going to be playing for you shortly. Very briefly, we are an immigration law firm. We practice immigration law in the U.S., employment-based immigration and family-based immigration, and throughout the world. And today we're going to talk first about the visa bulletin. The March visa bulletin is released, and no changes in the employment or in the India and China final action date and filing date as well, which was expected. As we've stated before, these visa bulletins recently has been released more seriously from one quarter to the other. If you recall, the October visa bulletin is the beginning of the fiscal year. Then we have the January, April, July, and then October, and then there's two releases between these two quarterly releases. And it looks like this administration or this visa bulletin consular affairs official that is working with releasing these are really not taking serious steps in the interim. They're looking, looks like, at the quarterly releases more seriously. So we're not seeing any changes from one quarter to the other in English. And not surprisingly, no change in March with regards to prior months. However, we couldn't but notice the commentary at the end of the visa bulletin for March, and it is talking about what to expect next month. And it's stating that, and I'm going to read the relevant part here because it's important to carefully evaluate that. Since December 2022, there has been higher than expected number use and demand, mostly due to continued new filings by applicants from all countries and priority dates earlier than the established final action dates. And this language is under the heading of visa availability in employment-based second preference category for all countries, including China and India. And then it goes on and says, this will necessitate corrective action in the coming months to hold numbers within the maximum allowed under the fiscal year 2023 annual limit. English translation: we expect further retrogression in the world visa availability, perhaps as soon as next month, and also for India and China. Furthermore, there is more language in the EB3 category, but it does not list India or China, also indicating that the worldwide final action date, including Mexico and Philippines, may be retrogressing, but not necessarily mentioning China or India. This is obviously bad news for EB2 and EB3, China and India, because when the worldwide is retrogressing, there is not extra visas or surplus to pass to the India or China EB2 or EB3 categories. So this is a bit of bad news. So this year, I guess, is the year of retrogression for us. Further retrogression was made this year in the EB5 India, and also an indication that maybe more retrogression in EB5 India coming down the pipeline in the commentary. However, the EB5, certain EB5 categories remain current. These are for rural areas, which is there's 20% set aside of these visas, high unemployment areas, which is 10% set aside, and infrastructure, which is 2% set aside. So these 32% set aside EB5 are available worldwide, and they have not retrogressed, and we haven't seen any indication that these will be retrogressed. Now, if you recall, in the new updated EB5 legislation from Congress, they created these set aside to encourage investment in rural high employment and in infrastructure projects. So these remain available. So shifting gear to this very interesting topic, which is the Child Status Protection Act. A very important change in the law, and the commentary you will hear from us is a first cut. What does that mean? The law on the change was announced very recently, a few days ago, and there is more clarification down the pipeline, and once they clarify more, we will clarify to you more. So without further delay, we're going to go into the Child Status Protection Act update, and after that, I'll be taking your questions. All right. The Child Status Protection Act has changed per USCIS revised policy. We're going to be talking about it today. I'm Sam Shihab.
I'm Brian Burke. We're attorneys from the law firm of Sam Shihab and Associates based here in the fabulous Columbus, Ohio area. Every week at 6 p.m. Monday Eastern Time, we meet here to talk about employment-based immigration issues, and we have a really good one this week, Sam. It's the Child Status Protection Act. Like you said, a pretty big change in policy, and we're going to dive right into it.
And probably we have to say that this is a very early commentary about it. There's a lot to be learned, and there's gaps in the interpretations that's going to probably fill in with time. So on a very early look at this change,
yeah, it could develop significantly.
It has moved in an advantageous way for those who have children that may be going to be aging out.
Yeah.
Now, before I go into this, Brian, those who, and I want to say this up front, those who have received denials for aging out for their children, in the revised policy, USCIS hinted to a potential motion to reopen and reconsider these cases.
Yeah.
Not much clarification on this, but there's something that we need to jump on if your child has been denied an adjustment of status for aging out under the old law, but under the new law, the new interpretation, the new policy, they may not have aged out. You may be entitled to file a motion to reopen and reconsider, but let's talk about the specifics.
Yeah, I'm glad you brought that up. That could potentially really change somebody's life upside down.
Yeah.
So, Child Status Protection Act. Generally, it's children derivative beneficiaries of employment-based green card applications are only entitled to be derivatives until they reach the age of 21 and remain unmarried. The Child Status Protection Act, described really broadly, gives a child more time to be eligible for a green card and effectively keeps their age for immigration purposes under 21 for longer. So when we talk about, well, how does that work? We talk about a few key factors. One, it's how long your I-140 is pending. That's the date that USCIS receives the I-140 till the date they approve the I-140. The additional time that a child gets under the Child Status Protection Act is the duration that your I-140 is pending with USCIS, which a good asterisk on that is it's not always best to file your I-140 in premium processing because you could be depriving yourself or your child at least, the benefit of that longer processing time. The next sort of key factor in the Child Status Protection Act is your child's age at the time of visa availability. And essentially, when a visa becomes available, that's when you subtract the I-140 pending time. If that calculation, the child's CSPA age, puts the child under 21, they're still eligible for a green card. Also important is seeking to acquire a green card. Your child must actually seek to acquire a green card within 1 year of availability. So that's generally stated very broadly how the CSPA works, and what we really move into right now is, well, what's the change then?
Well, obviously you've given people a lot to consider.
Yeah.
And I know it's confusing.
Yeah.
So I'm going to say it my way.
I like it.
In English. Okay? So the Child Status Protection Act, all what it does, it gives your son or daughter more time to get their green card if they cross 21 based on a credit given to them to reduce their CSPA age. And that credit is based on how much the government delayed in the processing of an I-140 in the employment context. So if the I-140 is 6 months, it took 6 months, your child could potentially receive a 6 months credit, and therefore they could get a green card if they are 21 years and 6 months, because it gives them credit for that time. It's simple. It basically says that because the government took a long time to process a green card, we're going to give you extra credit.
Yeah.
Okay. Now the concept is wonderful. The application of it is infinitely complicated, and it's very case specific. Back to you, Brian.
Yeah. So what is the change then? So I had previously said, they give you that credit that you just discussed based upon the time the government believes a visa is available. And what they have changed is their definition of when a visa is available. So the previous policy was that a visa is considered available on the later of your I-140 being approved or the final action date becoming current. The new policy says that a visa is available on the later of the I-140 approval or the date that USCIS is willing to accept an I-45 application on the individual's behalf. To translate that into a bit more comprehensible version, it says they are willing, USCIS is willing to, is going to calculate your visa availability based upon either dates for filing or final action dates, whatever they're willing to accept in a given month.
Yes. Let's go into our simplified chart
to really see how it works.
To kind of explain to you, this is ultra simplified, but sometimes a picture is better than a
chart. And I think this will start make people going, oh, okay, here it is.
So here is, in this timeline, we just showed you that there's an I-140 example that the processing time was 6 months.
That's how long an I-140 is pending.
Has been pending.
Yeah.
Okay. So now let's throw in a timeline.
Yeah.
So if you throw in a timeline, in that timeline, so the I-140 processing time unrelated to the timeline, these are two separate presentations. They are not together because we're going to put one on top of the other here in a second. So there is a certain time the I-140 was approved, and then there's a certain time there was a date for filing in the future.
Dates for filing becoming available, right?
In the visa bulletin, and then maybe a year or two, I don't know.
Yeah.
Or 6 months.
The bottom line, though, is that
final action
the final action date is always going to become later, available later than the dates for filing, and that's what we're really showing here.
So now we're going to put how the old law applies.
Yes.
So under the old law, the 6 months, we just took that chart and we put it on top of the timeline, and we put the end of the processing time on top of the final action date, because that's the date when visa is available, and you calculate backward.
Yeah.
In this example, the child turned 21 before the CSPA age. If you see that little turns 21 arrow. Yep. And therefore, under the old CSPA law, the child did not benefit from the credit received for which is the processing time, because they turned 21. Even the credit did not allow them to be able to adjust their status, because their age still before the beginning of that CSPA age.
Yeah, under the old policy, the critical time is when the final action date becomes available, and they say, okay, final action date's available. Let's give this child the benefit of that 6 months in our hypothetical. Oh, it took him back in time. It took him his age back in time, but not before the age of 21. Oops. Yeah.
So before we show the next slide, let's assume under the new law now, this new interpretation, let's assume that USCIS is accepting the dates for filing, not the final action date.
Yeah.
Right?
Yeah.
So let's see what happens to the...
Yeah.
Boom. So now you move that slide, that processing time, and you put the end of the processing time on the dates for filing, and boom, that turns 21, that child gets a green card.
Yeah.
In the old one, if you show the old one again.
See if I can get back to it. There it is.
Yeah, the child did not get a green card under the old law. Boom, under the new law, the child gets a green card. So hopefully that illustration shows you how USCIS is interpreting it. They're saying that we are subtracting from the dates for filing, if we're accepting adjustment for the dates for filing, we're subtracting that 6 months processing time from the dates for filing. And in the scenario we gave you, obviously to highlight the law, in that new interpretation, the child gets a green card. Under the old interpretation, in the example, in that illustration, the child does not get a green card.
Yeah.
And that's how the change in the law is impactful.
Yeah.
So that opens the door for a lot of confusion.
Yeah. So
first of all, what is the negative impact for everybody else?
So more green card. There are people out there, who might have not gotten a green card, right? And now with this new policy, they'll get a green card. And if more people are getting green cards, it means that people who are earlier, means the visas are getting eaten up that weren't going to be eaten up, meaning it slows down the movement of the visa bulletin, or could even contribute to a possible retrogression further.
It could be very significant.
Yeah.
Because now there is no calculation that I'm aware of, but it's going to be significant, that's going to say how many more green cards are going to be given to children as a result of this law, which is a wonderful thing. It's a wonderful thing. But for those who don't have children, they're going to say, now I'm delayed because every green card handed out to an extra child that would not have received a green card, it's less green card available for the employment base.
Yeah.
And unless USCIS and Congress does the rational thing of decoupling these two dates, meaning that they should not be subtracting green cards.
Every family member, just the primary applicant. Yeah.
Unless that's happened, we expect more slowing movement of the green card, of the visa bulletin as a result.
Well, true, but one of the sort of nuances here is that USCIS every month decides whether or not they want to go by dates for filing or final action dates. So USCIS does really get to arbitrarily control every month, whether more kids get green cards or if they don't.
That's the second problem.
Yeah.
So the second problem is, it's bad enough that the unpredictability of the law is really bad, because when there's a law that is unpredictable, it's a bad law, because people cannot plan their life based on whether my child was getting a green card or not, right? To begin with. Now it's even worse, because USCIS 1 month is going to say, well, we're picking up the final action date. And that slider that we showed you, it has to move for the final action date when you calculate your son's or your daughter's CSPA age. And in the next month, they can go back and say dates for filing. And then all of a sudden you have to calculate it based on a different rule. It creates confusion.
Yeah. And the other sort of interesting thing here is that this is USCIS policy. This is the USCIS policy, comes from the USCIS policy handbook update. And what we don't know about as of today when we're recording this, whether the Department of State is going to get on the same page as USCIS.
And if the Department of State has a different interpretation, it's more chaos.
Yeah. So we spent a lot of time before this presentation sort of talking about what that might look like. So And we didn't really touch much on sought to acquire, but I guess imagine this scenario: USCIS in a given month, they are not, let's say Department of State actually does adopt this policy, right? They adopt the exact same policy as USCIS, but as of right now, Department of State is always willing to accept dates for filing, right? So imagine, your child's here in the United States, they're getting close to aging out, and under USCIS policy, USCIS says this month, only final action dates. Okay, I guess I'm not locked into the Child Status Protection Act yet because I can't. My visa's not available in the eyes of USCIS. But the Department of State adopts a policy where, oh yeah, we agree that we'll go whatever is earlier, and Department of State always accepts dates for filing. Children can be finding themselves in a world where, ooh, I have to go get my green card through the consulate to lock my date in because the Department of State will lock it and USCIS won't right now.
So what you're saying, to begin with, the Department of State has not yet announced that they're adopting the same law.
Yeah.
So if they adopt two different laws, it's going to create chaos because clearly there could be a situation where an adjustment of status through USCIS is going to be giving the child an opportunity to get a green card where the State Department process will not give the
that's true.
So you have one country, two different agencies. One can get a green card through the agency, but the same person cannot get a green card through the other agency.
Yeah, you're right. So that's where we're at now. And I kind of jumped to a scenario, even if they adopt the same policies, but Department of State maintains their policy of always accepting final action dates, it's same policy, different results because USCIS chooses every month whether they go by final action or dates for filing, and Department of State always is willing to accept a case based upon final action dates. And basically we were talking, the only way to ensure equal results on these is if Department of State essentially accepts USCIS's determination as to what dates to use every month, which we don't think seems very likely.
So what you're saying is even if the State Department accept the same policy, we still may have a problem because
they accept different dates.
Unless, which is extremely unlikely, but it may happen, but extremely unlikely in my opinion, as I said today, which is February 18, 2023, so we can lock that presentation with this date, that the State Department is going to now defer to the USCIS on how to interpret the Child Status Protection Act on a monthly basis based on their date, which is unheard of.
Yeah, so let's talk about the nature of the Visa Bulletin. For those who aren't aware, the Visa Bulletin is published by the Department of State. They publish the final action dates, they publish the dates for filing. And then USCIS, in their own little realm of adjustments of status within the United States, they say, okay, this month we're going to accept dates for filing or final action dates. And fine, that's fine for what USCIS does in the United States, but the Department of State controls green card applications outside the country, and they say, we're always going to accept, get your green card process based upon dates for filing because we control things outside the United States. USCIS controls things in the United States. And the only way to basically make sure the results are equal is to make sure they're always accepting the same dates, and that means Department of State will basically have to cede to USCIS's interpretation of the Visa Bulletin on a monthly basis, and why would they do that? They're the kings of the Visa Bulletin.
Yeah, exactly, right?
Yeah.
So there's a lot of unanswered questions on this, and I will be interested to see how it plays out. Now, the next point is what I mentioned at the very beginning, and I'm going to read it. I got in front of me here just to say the USCIS's age calculation policy alert that was published on February 14th, 2023, and on the very date of the publication of this policy alert, they said that this law is effective on or after February 14, 2023.
Okay, great. So me as a lawyer, one of my questions is always, hey, when does this thing take effect? Okay, all cases adjudicated by USCIS on or after February 14th, 2023. It initially seems very clear that this applies to people moving forward, and if your decision was made prior to that, you're out of luck. However, this very thing you talked about the top of the presentation, what do they say, Sam, about emotions on this?
It begins with the word in addition.
Yeah.
So they start in addition. Okay. When you say in addition or however,
Everybody
To
after
me-
February 14th gets this, but in
In addition, non-citizens may file a motion to reopen. I'm reading. Their previously denied adjustment of status application with USCIS using a notice of appeal or motion. Wow. And it doesn't even tell you how far back. They just have this broad language that you have to show.
I will keep on reading it. So the rules for an I-290B motion are 30 days after the decision, right? So, and it says here, non-citizens must generally file motions to reopen within 30 days of the decision. That aligns with the policy we know.
Generally.
Yeah.
Underline the word generally.
Yes, but there's always an exception to that policy, and this is where it kind of blows my brain open. For a motion filed more than 30 days after the denial, if the non-citizen demonstrates that the delay was reasonable and beyond their control, USCIS may, in its discretion, excuse the untimely filing of the motion. So that is the standard policy.
But what would be beyond their control? Changing the policy.
Yeah. Okay. Here's my motion. You denied my case, a year ago, and because policy at the time did not allow me to get a green card. Well, now it does. That was beyond my control.
Please reopen the case and use this new law.
Yeah, and I mean, it sounds like for an attorney, it sounds like a really fun case because they have left a big giant door open.
Huge.
And I just want to push as many people. We're immigration attorneys. We like it when people get green cards. We just want to push as many people through this door.
How many of those are going to get filed?
Yeah, I mean, they talk about they published guidance on the CSPA back in May of 2018. Does it go back to May 2018, or does it go back to the very first date they published the date in 2015 when they first started adding dates for filing to the visa bulletin, And how do you answer the issue of sought to acquire, Sam? There's a requirement for CSPA benefits that you sought to acquire. What about the people who never sought to acquire a green card because, well, oh shoot, I was already aged out under the CSPA?
So I'm just envisioning. Yeah. I have absolutely no basis for what I'm saying, but it could be that the 1 year sought to acquire is the window within which USCIS may be willing to accept a motion to reopen.
Yeah, that's a
It's kind of a reasonable timeline. So they have, because you cannot go back 5 years and 6 years. It's impossible USCIS is going to accept that.
Oh yeah, no. If you want to see a retrogression,
be a 50-year retrogression.
Yeah.
But it could be the 1 year sought to acquire. So the 1 year sought to acquire, just to explain to everybody, USCIS says when your visa becomes available for your son to adjust or your daughter to adjust their status, and let's assume they received credit under the CSPA, and now for their CSPA,
your priority date was current. You were locked in under the CSPA.
Is under 21. Yeah. Let's say your child under the CSPA now is 20 and 11 months, so they can file. Now, when are they allowed to file? They're allowed to file within 1 year of that window opening for your son. That's called sought to acquire. If you don't take action within that 1 year, that CSPA age disappears. Yeah. Your child has lost their opportunity.
The door's not going to be open forever. We give you 1 year after your date.
And there's complex calculations on the retrogression. If there's a retrogression within that 1 year period, you get a new year, by the way, an additional year, when the visa bulletin becomes current again for your child. Now, it is very likely, pure interpretation, that the sought to acquire window could be the motion to reconsider window. Yeah. Very likely. But not very likely, likely. Yeah. We don't know. But clearly there's opportunity for you guys who have received denials of your adjustment status for your children.
Yeah, I guess they seem to require here that you actually filed that I-45 and lost the case. But I guess what I'm saying is I sort of feel for those people who said, oh no, I can't file that I-45 and didn't.
Yes. Yes.
Yeah.
Wonderful. So that is the Child Status Protection Act. Anything you want to add, Brian?
I would say CSPA is always great, always cool. It gets, for the little chart we showed, it gets better for people, but also the CSPA gets more complicated.
Yes.
Right? So there you go, yeah.
And I, not Brian, I will come back and answer all your questions when we come back. I'm told I cannot be heard. So hopefully now I can be heard. So hopefully this was a good summary for you guys on the Child Status Protection Act. And that, as I stated when I was on mute, this is a first cut. The law just got released. We anticipate there is going to be a tension between the implementation, potentially, between the State Department and the USCIS. We don't know what the State Department is going to be coming out with, but there's a language in the guidelines issued by USCIS that the Department of State, there has been coordination with the Department of State, and the Department of State will follow suit on the processing of immigrant visas and family immigration and the applicability of the Child Status Protection Act. And then the big elephant in the room is the motion to reopen and reconsider on cases. How far back can we do those? Initially, when I recorded this yesterday, I thought maybe during a 1 year period. And I'm thinking about it now. It could be more. And I'm just reflecting a little bit that the Child Status Protection Act law came into effect to avoid allowing government processing delays affect what child gets their green card and what child doesn't get their green card. It looks like we're back to square one. Now, government delays, i.e., whether they choose the date for filing or final action date, because that's basically on workload, will determine what child will get in and get their green card and what child will not, which is very disappointing because the whole idea was not to penalize someone because the government is not able to do their job. Back to square one. So is there potential litigation there? Probably not. But is there potential for confusion a little bit? Yes. Motion to reopen and reconsider, I think, is a wonderful opportunity for those that missed the boat. All right. So let's go into questions and answers. And I have in front of me one question that came in before we went live from Rami Love. I'm going to just address it very quickly. And Rami says, good evening, Sam and Brian. With March Visa Bulletin 2023, do you think EB3 India August 2nd, 2012 has any chance this year? It was mentioned due to high demand, final action date will be established for EB3 rest of the world. Well, right now, so everybody knows, we have EB3 India August 1st, 2012. So the question is it going to move one day at least? And you know, I don't know. I mean, I would love for it to move forward at least a little bit for Rami Love, or is it a date that Rami just picked up? I don't know. I don't have visibility into the future. Is there going to be a forward movement? Everything is indicating negative, honestly. But there's still time left in the year. So let's keep our fingers crossed, Rami. I cannot in good faith answer that question, but I found if in fact that you're stuck by 1 day, 2 days actually, because August 1st, 2012 is not processing anything prior to that date, to the Visa Bulletin date processing. So if you're really stuck by 2 days, that's a heartbreaker. Moving on to the next question from AK. Why are they counting family members in EB green cards? Can they stop counting family members? Well, that's the way USCIS have interpreted the law, that the 140,000 green card limitation is not only for the employment applicant, but their family members as well. So if you are a family of 5, you will consume 5 green cards from the total 140,000 green card. I think it makes a lot of sense to decouple that, because the Congress, when they passed the law, I think the limitation was imposed on how many professionals do we need every year. And of course, this 140,000 limitation that was set by Congress back in the 1990s did not put in consideration the incredible increase in demand for IT and engineers in this country, we did not have internet. We did not have cybersecurity. We did not have financial technology, fintech. We did not have self-driving vehicles that rely on technology for safety and security of the people. We did not have EV cars. So the 140,000 is 30 years outdated. I agree with AK. It should be changed, but today this is what we have. From Siva, I got a question that says, EB2, I-140, I-45 filed together on November 25th, 2022. Final action date current. Kids under 21 on H4 and I-140 approved on December 1st, 2022, but final action date retrogressed to October 2011. Filing date current in January 2023. Is child locked? Per the new policy, you have a hope that the answer probably yes, but I cannot say yes without looking at the case and calculating the numbers carefully so I can give you excellent information. But I strongly recommend that you have counsel look at your case, because under the new policy, USCIS is now considering visa available whenever USCIS accept the filing date, as it did back in January of 2023. So I'm giving you hope, positive hope, that yes, more than likely, but the answer will depend on having counsel to look at the dates for you carefully and without delay, so you can get definitive answer. And good luck for you, Siva. Sky limit. Hi, Sam. EB2 priority date for an applicant is December 2022, and his spouse's priority date is December 2019. So 2 separate applications. In EB2, looks like both of them. If he qualifies for EB1, can he port his spouse's priority date for EB1 instead of his? Sky limit. Your friend cannot port the spouse priority date to himself when he applies for EB1. His priority date is 2022, hers is 2019. The fact that they're married, they cannot pass on priority date to each other for a new application. But as we all know, he can benefit from the 2019 priority date if he is a derivative to him. Next question by Mr. Senchar. Senchar, how are you? Hi, Sam. Will H-1B status be lost if dependent uses I-485 EAD? Interfiled back to EB2. Will the dependent be able to get green card if EB2 date becomes current, or will they have to wait until EB3 becomes current? All right, so let's take the first piece for Senchar. Will the H-1B status be lost if dependent uses 485 EAD? The H-1B will not be lost because of the dependent. Now, their H-4 may have to be reestablished, but the H-1B principal dependent, H-1B will not be changed. On the second part, interfiled back to EB2, will the dependent be able to get green card if EB2 date becomes current, or will they have to wait until EB3 becomes current? Well, that's an excellent question. Number one, Senchar, again, I hate to say this, This is a critical issue, and you really need an attorney to look at this careful for you because time of the essence. If the child use of EAD in less than 180 days, INA 245K might save him because he's allowed to be outside of his status for up to 180 days. So that needs to be looked up carefully. So there is an opportunity there for us to be able to do that potentially. But again, the devil is in the details on many of these cases. All right. Moving on to Bavary Oak. Concurrent filing of I-140 and I-45 based on filing date chart, followed by retrogression. All right? Do we have to wait for filing date to become current again after I-140 approved? Absolutely yes. The answer is yes. And now your question does not have anything related to the child or the child aging out, but I think you may have a part 2 question potentially for the child age to be locked out. For the locking of age in general, in a retrogression situation, the I-140 has to be approved for that to be locked in because the visa availability date is the latter of 2 events. The I-140 approved and the first day on the visa bulletin in which your priority date is current. So the latter of those 2 days becomes the opportunity to lock the date. So potentially yes, and again, with the Child Status Protection Act, it's incredibly fact specific. So as a general answer, yes, with a retrogression, the I-140 has to be approved. With a specific question on locking your child, have it checked out carefully because these are very critical dates, and I don't want to give wrong answer to people. So Robbie Verma got a question for us today. My dad has a B2 visa plus Canada visitor visa. Okay, so he has a US visitor visa and a Canadian visitor visa. During the visit to the US, we want to go to Canada by driving. Would it cause an issue for him to re-enter since he technically makes 2 entry and any additional documentation needed? Well, again, our business is all about facts. I would be interested to know how long he is staying in Canada. Is he staying, for example, going to Niagara Falls for 1 day, crossing to the other side and then coming back, or he's going to spend a month or 2 in Canada and returning? Regardless, because his trip probably has an itinerary of going to Canada and coming back and then maybe returning home, an overall itinerary and an explanation at the first entry, it'd be helpful so the officer hopefully can enter on his computer some notation. Hopefully when your dad is crossing back to the US, it comes in handy. If he's traveling on the same day, I would insist to clarify it to the officer so you can be clear. But I don't see a problem as long as you're showing the itinerary, lay out the details, and explain to them that they were in the US. We wanted to go to Canada to visit a cousin or to go to Niagara Falls or whatever, and then come back to the US, and you can show the airline ticket flying back. I think as long as you can show that, you should be in good shape. All right. Moving on here today to Snehal M. Thanks for your help. You're more than welcome. I got an RFE to enter file from EB2 to EB3 saying my priority date is current in EB3, not in EB2, even though it is not current. Priority date 2013, I do already have second I-45 pending in EB3. Any thoughts? Well, Obviously, you decided to take advantage of the transfer underlying basis to enhance your chances in consultation with your attorney and your own knowledge and intelligence. As a smart guy, you've decided that you want to do an interfiling, and USCIS responded with a silly RFE. You just need to explain it to them. You need to teach them the law in your response, that my EB3 is not current. I have another one. I want to move forward with the interfile, and exhibit the visa bulletin with the appropriate highlights at the appropriate areas, and then send it back to them. I'm thinking of not interfiling and replying to USCIS saying I have a second 45 and E3 pending and request to consider them in EB3. Appreciate your input. Yeah, you can definitely do that. But if the priority date is not current in EB3 and they're telling you it is, there seems to be an error. Obviously, looking at the totality of the case, looking at the history building up, trying to kind of find out why they're asking you to do that. Because if they're telling you it's current, well, and if it's not current, that's not rocket science. But if they're telling you that they have pulled a visa number and there's a visa number available that was pulled for you from before, and do you want to take advantage of it, that's a different question. So the devil is in the detail on that scenario. To advise you without looking at the RFE would be probably not the right thing to do for you, but the facts are the facts. If they're saying something wrong in the RFE, it's an error. As simple as that. Hari Guru, question 1 of 2. Sam Bryan, with the current visa bulletin and retrogressions on most of the categories, can you please comment on who holds the responsibility for this kind of mess we all are dragged into? All right, well, there's no question here. Who holds responsibility? I guess there's a question. Who holds responsibility on this mess? And mess being not being able to get your green card. Well, let me, before I go into the second part, let me see if I can answer that question. You filed for a green card timely. You did everything right, Hari. You went to college, you got your degree, you came here, you worked hard, you worked endless nights to get your achievements. You interviewed, you got a job in America, you applied for an H-1B visa, you followed all the rules, and here you are stuck. Congress does not want to act and caught up in petty political garbage fights between them, the Republicans and the Democrats. The president does not want to take action administratively and say, decouple the family from the employment base, and we're not going to count the family members, and we're going to just apply these green cards, or we are going to recapture the 700, 800, I forget what number, 1,000 green cards that were lost for decades because of incompetence of USCIS, and including the 60,000 that was lost last year, so we can treat people the right way. So who holds the responsibility? I think we all as a community hold the responsibility. All of us are responsible. We elect Congress, we elect the president. They're all subject to special interests and lobbying money. There isn't enough. Our own community. I mean, I go to a lot of the company owners, parties, and get together. They own companies in which a lot of you guys work for. There's no interest on their part to move this green card process faster. Why would they? They would lose a lot of people. Not everybody. A lot of them care. A lot of them get nervous when they hear that the green card is going to move quicker, or they're going to allow national interest waiver and allow more people or increase the numbers because they're worried about loss of employees. So who is to be responsible for this mess? All of us are responsible for this mess, Harry. Censure. Guru, how does this rhetorical question alleviate any of the mess we are in? Well put. But it's a frustration, Censure. Harry is frustrated. And because he's frustrated, he is expressing his frustration here. Question 2 of 2. Is it with the Department of State, USCIS for slow processing, wastage? Is it with attorneys who wildly encouraged for downgrade, upgrade, and finally with people with their application submission on EB2 and EB3? Wow. Back in October, 2000? Time flies now. When we had this massive EB3 movement, and everybody downgraded into EB3 and filed I-140s. And then USCIS said, oh, what the heck? EB3 is so backlogged. Let's back up EB3. Let's move EB2. Let's get people back. If I tell you, Harry, in October of 2020, I think, that's the date, I don't think it's a good idea for you to downgrade and file an I-140. What would you do? I can tell you what you would do. You would hang up on me and call the next attorney who will take your case. And when your EB2 moved and EB3 stuck, if I told you it's not a good idea, of course, I wouldn't tell you. I would tell you it's a good idea to downgrade the first time. I would tell you it's a good idea to downgrade the second time, because that's the best recommendation made by any attorney at that time, given the information we had at that time. Unless, when we graduate from law school, we get a crystal ball, which is right here. Let me see if I can point to it. Right here, my crystal ball. We don't know the future, Harry. We tell you, recommend to you based on information we have at the time. And by the way, if I told any of you guys not to downgrade in October 2020 or not to upgrade when it flip-flopped, you would simply go to another lawyer. But it doesn't matter whether you go to another lawyer or not go to another lawyer. I will always tell you what I think. And it was the right thing to downgrade the first time. It was the right thing to switch back the second time. But who is to blame? I guess, like I said, I haven't changed. All of us. Congress, President, USCIS, Department of State, but not your attorney, that's for sure. If you're mad at your attorney, you're channeling your anger to the wrong person. All right, so I think we fixed the audio. All right, wow, that was a lot. Works now, okay, all right, fantastic. All right, back to the questions. Wow, Harry got me going here. Sriva, my 485 case changed to case ready to schedule for an interview. Still no date yet since 20 days. If I travel abroad next on advanced parole, is there any risk of my green card? Can they cancel green card because I travel? In general, interviews are scheduled about 40 to 60 days in advance. So you have a travel time for short travel. You have to be prepared mentally to come back quickly if there is an interview and if your priority is in fact current. Um, so if you don't have anybody that's monitoring your mail at home that is very reliable, I wouldn't travel. I would try to stay put here for a little bit longer. But I know you have plans with the family. You've worked hard to to take your vacation, and you don't want to disrupt it based on a note. But this is a very critical process, and maybe the deal is I will travel, but the family has to be prepared to travel right back if there is a date. And if you are 100% have a reliable person to check your mail at home, then I would probably be comfortable. And sometimes people have to make tough decisions, Sriva. And I know with spring break and the kids and the wife or the spouse, I don't know. I know it's not easy. It's a tough decision. I would not travel, but that's me. You can make the decision for yourself. All right. Nijam Pudi got a question for us today. My priority date is May 2015, but my son aging out this year by December. Can I expect any filing date moving in this year? With 2015, and we are in 2012, I don't know. But the question, and I don't have the dates committed to memory, is whether or not the filing date was current for 2015 before, and whether, I don't know when the I-140 was approved, whether you are ripe for a motion to reopen and reconsider based on this new policy. Looking back, would you have been locked in? Would your son have been locked in had this policy that's implemented now was in place back when a year ago or 6 months ago or a year and a half ago? Question mark. If the answer is yes, it might be ripe for a motion to reopen and reconsider, because if you've listened to our presentation, USCIS hinted to amenability to accept certain motions to reopen and reconsider. So this is an opportunity. If it makes sense, we would have to look at it, or a competent lawyer has to look at it for you and help you out on that in that regard. Mota, priority date EB3, January 6, 2014. I don't know what that means. I think there's a question after that. Filed 485 in October 2020, and date of birth is February 24th, 2001. So I think her age is locked now. Even final action date is never current. Potentially, yes. Again, need to have a lawyer look at that. The policy effective date is February 14, 2023. So when USCIS already adjudicated your case, they should apply this new policy, and it looks very favorable based on what we're looking at here. But again, Child Status Protection Act, man, this is scary stuff. You need somebody carefully to look at it for you to be able to help you out. She got an EAD advanced parole till July 23, and she is studying F1 EAD OPT. So now she can file for her renewal of EAD for my adjustment status and stop using F1 EAD OPT. So basically, she can, if she has, well, potentially, yes, potentially, absolutely. But again, we got to look at that carefully for you, and you're thinking in the right direction. Absolutely. Engage an attorney on this to help you out with it, Mota. You're thinking very well. And yep, I love the fact that people are benefiting, which is wonderful. All right. So Robbie Verma, they stay in Canada would be for 5 days for visiting. Yeah. I don't see a problem, Sarabi. Explain it to the officer when you cross the border. Make sure you mention it that they're coming in for 5 days, that they are only, and the purpose of their visit, so he can hopefully ask him if he can document it, because we're crossing back in 5 days, and if you can document something for us, maybe help us to get back home so they can fly out of the U.S. So that's a possibility that you can do to help with the parent visit to Canada. Faraz, does I-512 serve as an advanced parole at the bottom of the EAD card, meaning a combo card? I heard it should read I-512L serves as advanced parole. Letter L means anything? It sounds to me it's a combo card. The L means nothing to me, to be very honest with you. If it says on it, it serves as a 512 serves as advanced parole, that's it. It's an advanced parole. If you are in doubt, shoot an email, scan it, shoot an email to your attorney and say, hey, take a look at this for me, and let me know if there is a problem. We have hit the 7 o'clock hour. Thank you guys so much. I hope I was able to fill in. I know Brian is colorful and exciting, and he will be back next Monday to join us for our presentation. Until next Monday, you guys have a fantastic rest of the week.